Hi everyone, Ryan Flugar again with the National Association for Gun Rights. Ding, it's round 2 in the Supreme Court over our lawsuit against the city of Naperville and the state of Illinois. If you're following our channel, then you already know we're trading blows with the anti-gun lawyers over our emergency appeal to the United States Supreme Court and Justice Amy Coney Barrett's demand letter for the city and state to explain why they think they can ban guns and get away with it. If you don't know this yet, hit the subscribe button because we're actually suing in 7 states. Count them, 7 states to overturn similar assault weapons bans and magazine bans all across the country. And if you want to get involved in the gun rights fight, click the link in the description or the pinned comment down below to sign a petition and take action in the future. We're trying to end all bans on ordinary semi-automatic firearms everywhere for good. So subscribe now to get all the latest developments. But back to our case in Illinois. Here's what's going on right now. The anti-gunners have filed their brief to Justice Barrett trying to explain why they think they can ban guns under the Second Amendment and the Bruen decision. And my colleague Hannah Hill went over all the flaws in this crackpot filing in her video yesterday. Check it out, we'll put that in the description too. Today, we get to file our formal rebuttal to their anti-gun arguments. In fact, our attorneys just hit the submit button to the Supreme Court on a brief that should blow the gun-grabbing legal gymnastics out of the water. I'll go over details in a moment. But first, let me explain the lay of the land in this legal case and where it is. The federal court system is like the world's worst IKEA store. We started off with the novel concept of filing a lawsuit to overturn unconstitutional gun bans. Pretty simple, right? Wrong. From the moment we hit that submit button, it's like a maze of filings, responses, hearings, dates, and deadlines. We started off in federal district court simply arguing that the city of Naperville's newly passed assault weapons ban violated the Bruen decision and the Second Amendment rights of all residents of Naperville, Illinois, including Robert Beavis, the owner of Law Weapons, a local gun shop who is on the lawsuit with us as a fellow plaintiff. We simply asked that judge to enter an injunction so the law could not take effect while the litigation was ongoing, so Robert's business wouldn't suffer through the duration. Sadly, that judge said no after misapplying the Bruen decision. So we made an emergency appeal of that decision to the 7th Circuit Court of Appeals, which also refused to overrule that judge. And now we're appealed to the Supreme Court, where Justice Amy Coney Barrett has taken the very unusual step of engaging in the case. Now, most cases never make it this far, especially before the litigation on the merits pans out. But we owed it to Robert to try because his business is suffering and it could be forced to close down. Now this case is making front page news because if Barrett grants the injunction, it could be the most significant legal decision on the Second Amendment since the Bruen decision from last year and assigned to all lower courts that are handling semi-auto ban cases. Even without granting the injunction, it's already sending shockwaves across the legal sphere in places like Washington and Delaware and Oregon, where newly passed gun bans are facing similar legal challenges. It tells the courts that the Supreme Court is watching you, and you better follow the Bruen decision correctly, or when this case does make it back through the normal non-emergency appeals process, the Supreme Court might just put an end to all of these illegal gun bans for good, and we're certainly hoping that's the case. So that's where we are here. And it's why you've probably seen so much about this case on YouTube and in email and in the news. But truth be told, we could be far from the end of this IKEA store, and we may still get sent back to start. And we may have to make another pass at it before it's all over. But the point is we're on the right track to winning this lawsuit, and we won't rest until we do. So I'd like to read a few excerpts without further ado from our latest rebuttal filing just filed this morning, so you can see how exceedingly simple this case is. Here's our first excerpt. The state makes the argument that banned firearms are not indisputably arms within the Second Amendment's plain text. This is more than just incorrect, it defies common sense. All firearms are arms. The Second Amendment extends prima facie to all instruments that constitute bearable arms. Therefore, the text of the Second Amendment, prima facie, extends to the banned firearms. Excerpt number 2. Bruen, the Bruen decision, unambiguously rejected the applications of a means-end scrutiny in the Second Amendment context. Nevertheless, the state candidly admits the law should be upheld because it, quote, promotes a compelling interest in protecting the public and is narrowly tailored. Well, if that's not a backdoor appeal to a means-end scrutiny, it's difficult to know what would be. The whole point of Bruen is that it is not legitimate for judges to make empirical judgments about the costs and benefits of firearms restrictions. Accordingly, the plaintiffs, us, will ignore the state's means end red herring, and we hope that this court will as well. Excerpt number 3. A few dozen people have used arms like those banned under the challenge laws to commit horrific mass shootings. But the arms used in these events account for less than 1/100th of 1% of the millions owned by law-abiding citizens who, as Justice Thomas pointed out, overwhelmingly use them for lawful purposes. The question before the court is whether these millions of citizens' rights should yield because of the bad acts of dozens. Heller answered that question in the negative, and the plaintiffs, us, urged this court to answer that in the same way in this case. Excerpt number 4. The state points out that since Bruin, the lower courts have almost uniformly denied relief to the Illinois law and similar laws in other states. It's unfortunate, but hardly surprising, that the lower courts have been upholding plainly unconstitutional laws burdening Second Amendment rights. The state believes this is a reason to deny the application. Plaintiffs respectively suggest that this is perhaps the best reason to grant it. Now, I hope you can see what's before the court here, and why the fact that Justice Barrett's review here is so significant. Just the mere fact that she's looking at it. Of course, truth be told, any action by Justice Barrett short of no action would be huge, and we'd welcome taking the shortcut to the decision that we all know is true and right under the Constitution. But win or lose at this stage is just one round in the larger fight. The National Association for Gun Rights will see this case through the courts until we ultimately prevail on the merits, and we're going to keep fighting to overturn the same gun bans in our other cases also. In addition to Illinois, we have Hawaii in the 9th Circuit, Colorado in the 10th Circuit, Massachusetts in the 1st Circuit, and Connecticut in the 2nd Circuit. That's more than half the country. So please hit that subscribe button if you haven't already, and head on over to gunrights.org to learn more about how you can help us in these cases and in our fight to protect and restore the Second Amendment rights of all Americans. Thank you and God bless.